This is Labour's first private member's time in the new Dáil, and we had no difficulty in choosing the issue we wanted to prioritise. The last government was devoted to cleaning up the economic mess. Now Ireland is in a strong position to grow again. For my party's priorities are all about making sure that the benefits of strong growth are fully shared, about working to improve the quality of life of working people. For us, getting the economy back on track was not an end in itself. It was a means to getting people back to work and getting pay back into people's pockets. Who else in government would have ensured that Ireland uniquely delivered 2 rises in the minimum wage against the backdrop of the worst economic recession in our history? As the economy continues to recover and unemployment continues to fall, we want to see the benefits of recovery translated into better working conditions and improved pay, particularly for low-paid workers. Of course, the world of work is changing fast. Workers have adapted to more flexible terms and different working conditions. But in all of this change, we need still to protect the basic requirements of decent standards for working people. Work is not just an input into production. It's about human dignity and respect. For some people, the needs of the economy require labour to become commoditised. We reject the forced casualisation of jobs. We reject a future that sees workers become trapped in job and income insecurity and in a succession of short-term, low-quality jobs with no access to social protection. In particular, there are too many women now working in jobs that are poorly paid, insecure and outside or at the very edge of the employment protection laws. I and my party have no interest in the notion of jobs at any price, in the spread of casual labour and low wages. This government and this Dáil must not preside over an economic recovery model that is fuelled by a ruthless race to the bottom or the sacrifice of employment rights that have been hard-won, which are a mark of decency and a progressive society. What people want and are entitled to are sustainable, secure and reasonably well-paid jobs. So what we have outlined in this motion is a programme to tackle abusive terms and conditions of employment, low pay, insecure hours, enforced and bogus self-employment. We're seeking to continue with the work started in government. We reinstalled a Labour Minister for Labour Affairs, Jed Nash, whose role was to insist that this country needs more than just jobs, but quality jobs. In his period as Minister for Labour Affairs, he drove the Labour Party agenda of making work pay, enhancing dignity in work and reducing inequality. And that's why we set up the Low Pay Commission. It's also why we brought about new industrial relations laws to rebalance the interests of workers and employers. And that's why we've turned public attention to the abusive relationship that surrounds the casualisation of work. Let's be clear about this, Cathaoirleach. We are not a nation of Luddites. We have a small, open economy. We respond to the needs of the global marketplace. We recognise that there are sectors in the economy that place a premium on flexibility. But for us in the Labour Party, the basic requirements of a decent working life must be maintained. We want the right balance between enterprises' need for flexibility and a worker's right to job security, to a basic level of predictability in the terms and conditions of work. There's a growing number of people in precarious employment here, non-standard employment that is poorly paid or insecure or completely outside of employment protection laws. And precarious employment is not gender neutral. Women are invariably overrepresented in this type of work. In government, we highlighted several of these issues. I'll refer to some of them. Firstly, we commissioned research and recommendations on zero and low hours, which show that we have a serious and indeed a growing problem there. People working under these contracts are being told, in effect, that they can work on casual basis. For these workers, hours at work and pay slips can vary dramatically with no guarantee of any work at all from week to week. These workers know from they don't know from 1 week to the other what they're going to be paid or how they're going to face consistent bills. Erratic pay produces massive insecurity and is entirely destructive of any attempt to plan your finances, to plan a future for yourself and for your family. These are frankly perverse arrangements and are aimed at downgrading the status of employment. Workers are entitled to basic security in their employment in order to plan their lives for themselves and their families. We believe that this Dáil must legislate to bring these abuses to an end. But dealing with the phenomenon of this scale, protecting workers against the casualisation of work, will require more than just one quick-fix legislative amendment. It needs detailed collective consideration and the agreement of this House. Secondly, low pay must continue to be high on our agenda. The minimum wage is but a starting point. We want to go further. The minimum wage is our statutory floor. The living wage is different. It recognises that there are sectors in the economy in danger of becoming addicted to low pay, and that there are many employers who can afford to pay but refuse to pay more than the statutory minimum. The living wage is an independent, assessed and agreed measure for the income necessary to meet basic needs: housing, food, utilities, clothing, transport, health, childcare and recreation. And from the government's viewpoint, the living wage will boost taxes, reduces welfare spend and allows for investment in essential public services. I accept that progress on this will have to be incremental, and we can't do it as a stroke of a pen. In government, Minister Nash took the first steps to put this on the public agenda, a forum for employers, unions and civic society. The Dáil needs to go further. We need to look perhaps at the UK experience and at the benefits provided for society, for the economy and for businesses too. I believe we can assure that the state and all state agencies become living wage employers, and that we should impose a living wage on public procurement contracts. I also believe that in the lifetime of this government, increases of the national wage should be continued until it reaches 2/3 of median income. And I believe it's high time that we set about legislating for common and comprehensive definitions of employment and for self-employment. That for tax, social welfare and unemployment protection purposes, we've one definition. We need to crack down on bogus self-employment practices that exploit workers and leave them without legal protection. There was, in truth, only so much that we could do over the last short period in office. Minister Nash delivered on the Low Pay Commission, on the national minimum wage. He produced collective bargaining legislation, laws on registered employment agreements, sectoral employment orders and the re-establishment of joint labour committees. But like any busy minister, he left some work undone. Much of the issues that need to be addressed now are set out in our motion. We do not want to see the foot being taken off the accelerator of these important objectives. And that's why we wrote last week to all parties and all groups in this House, looking for consensus on these matters. When we drafted the motion, we hoped to attract support from a wide range of groups and parties. In fact, everybody with a progressive view of work. We wrote to all the parties. Typically, Sinn Féin immediately ruled out of hand our motion and rejected any effort at cooperating with us. It's not too surprising. Sinn Féin is a party of professional contrarians, opposed to everything and anything, including opposed to the opposition in this House. When an agreed road forward is clearly signposted, a progressive road forward, they go yomping off alone in the wilderness. And it turns out that the AAA are in exactly the same space, except they cannot even dissent by consensus with Sinn Féin and have taken their own separate amendment. The position of these two parties to our motion betrays not just their churlishness, but their ignorance of the issues. It passes belief that any party that seeks to support Irish workers could know so little about the current industrial relations landscape. Sinn Féin and the AAA say that we in the Labour Party did nothing to protect the rights of Dunstore's workers, and we failed to provide specific or adequate legislation. Don't they know that this very week the Labour Court is hearing the claim against Dunnes Stores brought by mandate, and that this claim is being brought about by the Industrial Relations Act that was introduced only last year by Minister Jed Nash. The Dunnes Stores dispute will be one of the first hearings under this new legislation, and I'm entirely in sympathy with Mandate in its struggle against the stubborn refusal of Dunnes Stores management to provide their workers with some certainty on hours and on earnings. The refusal of management to sit down and negotiate with workers through their union is nothing short of a national disgrace. The workers have shown real courage and conviction in pursuing their case, and I and the Labour Party fully support them. But I and my party did not just mouth off about this issue. We are not content with simply carping and whinging. We challenged the law, we changed it, and we put the workers on a proper footing. The new Act allows the Labour Court to intervene even when employers do not turn up, and it allows the Labour Court to issue binding determinations on pay and conditions that are enforceable in the Circuit Court. The Labour Court can now look to comparators, both unionised and non-unionised, and they can see what collective agreements have established as the norm for the sector. John Douglas and his union welcomed the Act. They are prepared to engage with the legislation and advance their workers. In the same way, Mandate has also welcomed our investigation into zero and low hour contracts. That is a real political leadership. It's real engagement, real cooperation with the labour movement in all its branches. It's the way that real progress is made. It's the way the Labour Party operates. As I said on the day I became party leader, Labour doesn't do theatrics. We offer real change, real solutions to people's dilemmas. Sinn Féin and the Trotskyites, on the other hand, have a critique but no solution. And quite frankly, they're out of their depth when it comes to genuine industrial relations issues. We are almost at the first anniversary of Cleary's liquidation. The liquidation was engineered so as to ensure that Cleary's building was separated from its employees and its staff. And I welcome into the gallery some of the Cleary's workers tonight to view this debate. These are actions taken by the company amounted to, I believe, an effort to subvert both company and employment protection law. We do need to emphasise that the workers are not out of pocket as regards statutory entitlements. The state became obliged to pay all the sums that were due to the company's employees. It's the taxpayer that bears this multi-million euro loss. And I hope that the Minister, in reply to this motion, will be able to give us an update and spell out in clear terms the current position on the various initiatives taken by Senator Nash when he was Minister in the previous administration. First, he published a report which outlined Companies Act provisions enabling the courts to ensure that all assets are sought to be available to the creditors can be clawed back to their benefit. There is yet untested section 599 of the Companies Act which featured in this analysis. The company pointed out that the Minister for Social Protection had standing as a preferred creditor in the winding up, and that this remedy was potentially available to her on behalf of the out-of-pocket workers. I understand that the Attorney-General has now advised on this issue, and I'd ask the Minister to inform the House on what action is to be taken in this regard. I'm conscious of time. I want to say that last year Ministers Bruton and Nash appointed 2 experts to examine legal protection for workers where operations and assets were moved to separate legal entities. Kevin Duffy, Chairman of the Labour Court, and Nessa Cahill, a company law specialist, have published their report and their recommendations. That is on the public record. So I'd ask the Minister to tonight tell us what her attitude is and what is the attitude of government to these recommendations. When can we expect to see action on foot of their report? It would be a pity if the change in administration resulted in a less impetus to drive forward these urgently needed reforms. The priority must be to ensure that situations like those that befell the Cleary's workers can never happen again. Our joint motion, or our motion tonight, meets that requirement, and I hope that it will enjoy support across the House. That would be the signal we will give to people under pressure in the workforce tonight. I commend the motion to the House.